right, well, I want to welcome everybody to this morning's episode of Forgotten Liberty Radio. John, how are you doing?
I'm good. Another Saturday morning.
It is. If you are watching live, I want to ask you to drop in any questions that you have. It should pop up right now. And if you're not subscribed to us on any of your podcast clients, please do so. This episode will be available as a podcast, an audio podcast. Later, you can also go to our YouTube channel and subscribe there. John, what you got for us today?
Oh, a little bit of this, a little bit of that.
As always.
Pretty much, what's going on in the news lately. We had a vice presidential debate. Everybody should have got their ballots by now. So we'll probably touch on some of the propositions, give you some of our recommendations, maybe where we're at so far. I don't make up my mind until the last minute, so I really can't tell you where I'd be specifically, factually. It may change. Like last night, I opened up the text of the Prop 22, right? That's the gig worker protection thing. Mm-hmm. Have you looked into that one?
No, I haven't.
So that's that where they're trying to Uber, Lyft, DoorDash.
Oh, yeah, I know what you're talking about.
They're all trying to combat the AB5. So,
yeah, Prop 22 here. I'm gonna put a link in the show notes so we have it.
Well, most everybody, at least on your conservative side, are a yes on 22.
Yeah, I mean, I saw ads on YouTube for it too. It's pretty widespread at this point.
Yeah,
I understand.
But then you take AB5, which is just a piece of garbage, right?
Mm-hmm.
And that limits what these Lyft, Uber, DoorDash, Amazon, all these app-based delivery services can do to the people that are delivering for them.
Yeah.
And it brought them into an actual legitimate employee-employer situation.
Right.
And now if you read the text of the proposition, well, it's not 100% doing what they're saying it's doing for all people. Like the commercial I saw yesterday said that it gives workers guaranteed wages. It gives workers, health care protection. It gives workers, the ability to have these things from the company, but yet still be an independent contractor.
Oh, interesting.
Here's a situation. If they're asking the people of California to say that because Uber, Lyft, DoorDash, et cetera, have agreed to, if someone is working off of that app 25 hours or more per month, based on their last, 4 weeks of activity on the app, then they're entitled to 120% of minimum wage for all hours worked. Yeah, that you just had up. That's what I was reading on your left screen there. Okay. So okay, you have to do 25 hours before you qualify for these things. What percentage, they're not telling us, are those that are doing that 25 hours? At 15 hours, you're entitled to health benefits of a certain percent, but the percentage of health benefits you're entitled to drops. The amount of money, it's all based on 25 hours is like 80% of the covered California rate. 15 hours is like 48% of the covered California premium rate. It's really ridiculous what they're trying to sell us here. Only those people are entitled to commercial vehicle insurance in the amounts set by the FMCSA, which oversees or the state of California for that matter, because it'd be intrastate at that point. And intrastate trucking companies are required to have a minimum of $750,000 insurance. So it extends those mandated insurances to the delivery service drivers.
Okay.
But only once they reach that certain percentage. Okay. Here's my problem with it. If you're driving your vehicle in commerce, which is what these delivery services or these app-based, gig-based delivery services are, they are directly competing with the business that I'm in. It's transportation regardless. If I have to provide for my semi-truck $750,000 insurance, every one of these people ought to pay their own insurance policy or be leased onto that company. And then at which point they're a company employee. Just like a truck driver.
Yep.
Okay?
Yep.
So let's see where the Howard Jarvis Taxpayers Association is a yes on 22. The Stanislaus County Republican Party's a yes. The Republican National Committee's a yes. The cops and this and that and everything that comes to your house except for the Democratic Party's a yes. And I'm going to tell you right now, as someone who has to pay these insurances, taxes, and fees and pay his own medical and this and that, I'm a no on 22.
Okay.
I'm a no on AB5. I think it's a bad deal, but this isn't the way to fix it because it only fixes it for one group of people. Again, that's discriminatory. It's not equal protection under this law either. And it doesn't even say that every one of them has to have the same insurance, the same registration requirements, the same...
Oh, okay.
Okay?
Yeah.
The same health care. It entitles them to employee benefit, yet makes that so the company can pay them on a 1099 and not have to pay the federal withholding, the state withholding, the other taxes. It's wrong.
Yeah.
It's discriminatory. And I'm a no on it.
Yeah. That makes sense.
Makes sense. And that's that one that everybody's for. You know? Everybody's for, but they don't look at the fact that, hey, on principle, I have to say no on 22 because it's not treating our industries equally. And my argument on AB5 has always been, if you go back and listen to our shows on AB5 and our interviews, it's not treating everyone equally. So it's constitutionally null and void. Regardless of federal or state constitution. We're supposed to treat everybody equal under the law, and simply because you can garner the requisite number of signatures and turn those into the state attorney general, it don't make it a yes. It's a no. It's a hard no.
Makes sense to me. Makes sense to me.
So, I mean, I haven't gone through too many of the others. We know they got the split roll stuff coming up.
Right.
You know. But here's where Howard Jarvis is on the statewide measures, since everybody has their ballots out. Howard Jarvis, being the Taxpayers Association, they're like a no on 14, a no on 15, a no on 18, a no on 19, a no on 21. They're a yes on 22, but I disagree because it's discriminatory. We just went over that. They're a no on 24, a no on 25, and then they get into your local measures. But I got to tell you, I got to dig deep and read these propositions and see what they actually do, what they actually say.
Yeah, I do too.
I don't think it's something the people should even be posed with the question of, do we allow this Uber, Lyft, DoorDash delivery service deal to take place when, okay, what percentage of those people exclusively use those app-based services for their income? I mean, the large majority of it, in my opinion, which is not based in fact, is just all people using it part-time, right?
Yeah, there's definitely a significant percentage that's the case, but I think there are a lot of people who do it full-time.
Well, if they do it full-time, then they need to go to their counties or their cities, whoever regulates taxi cabs in their area, the PUC, and they need to be a full-time taxi service, okay?
Yeah.
These are two totally separate and individual markets.
Yeah, I think that makes sense.
If you're door dashing all the time, you're a delivery company. You need to be competing on the equal to DHL, UPS, FedEx, California Overnight, GSL, and you don't need the protection from a proposition because you're trying to subvert existing state law.
Yeah, I agree.
You know, what do we got going on right now? We got a lot of executive orders flying around. Is the governor authorized to do these things or not? Well, we'll get over that in a later segment of the show probably, because that's one of the things I want to touch on, the Kylie Gallagher suit against Gavin there that took place. You know, they had a hearing this week. But the legislature absolutely has a responsibility to make constitutional laws concerning intrastate transport. They have done that. These are all intrastate transport areas, and let's be realistic with it. If you're subverting that or asking the voting public to help you subvert that, you're playing in dangerous waters. You go out there and you crash your car. You got an Uber Lyft sticker? Hope you didn't cut off this semi-truck driver, because I'm going to sue you for as much as I can.
Yeah, exactly.
Because you should have had those protections.
Right.
You're engaged in that business. Well, pretty much everyone but the Democrat Party is saying it's a yes on 22. Yes on 22 is just as bad as AB 5 in my opinion. I've read the text of the proposition, and it allows the companies, Uber, Lyft, DoorDash, those gig-based companies to discriminate against a percentage of their app-based users. You know, that you have to meet certain percentages of use before you're entitled to things that state law gives you as protections. And it will exclude you from insurance requirements that other transportation-based services have to pay. So for that reason alone, it's not equal protection for every industry. Again, it's just carving out one more caveat in AB 5. And I'm a hard no on that, because I've always been 100% equal protection on this thing, this AB 5 issue. And it's the same with 22. So, and staying with my values and morals and being a man of utmost integrity, I got to go no on 22. So,
makes sense.
I'm
going to drop the link for that in the description, the show notes description. So
yeah, I mean, I don't know if you agree or disagree, but you know.
So honestly, this was something I got my ballot, and I was looking at AB 22, or I was thinking about AB 22, and I mean, based on what you're saying, it makes sense. I don't know why. I mean, it makes the most sense, but I'm gonna have to read up a little more on it. Based on your recommendation, if you're saying no, there's a very good reason. There's a very good possibility I'll be voting no as well.
Well, I tell you everybody why I base my opinion, and mine's a little more than opinion, because opinions are viewpoints not based in fact. My viewpoints on this are based in fact. I've read the proposition. It limits at what point the service provider or the app owner has to kick in these wage and healthcare benefits for these transporters.
Yeah, and it's, I don't know. I understand that it's it's trying to roll back the damage that was done by AB5, but the problem is that at least what I'm saying is that it's not actually doing that. It's just putting further strain on Uber, Lyft, etc. Many of these gig-based apps, it's putting additional strain on them instead of relieving the strain that was placed by AB5.
How's it additional strain? They're in that delivery business, and they've been circumventing state and federal law the whole time they've been in operation. It absolutely was the way they and their lawyers thought they could get around a US DOT number or a PUC number or all of these. Hey, we want to be a taxi company and we want to make it easy for people to get in and out of taxis and use it here to there, do it app based, take that human dispatch component out of that industry. Okay, save some money. Take the lease, the insurance, the maintenance costs out of that industry.
Yeah.
Place all those on the person signed up through the app providing the service for someone else. Mm-hmm. But where's the consumer protection? Where's the general public protection? There's no commercial insurance policies on 99% of these Uber, Lyft, DoorDash cars. They're running on private insurance.
Yeah, I guess
not commercial insurance. And if they get in an accident with you under those insurance policies and the insurance company finds that they're driving for Uber, Lyft, DoorDash, they're not going to cover it.
Yeah.
They're going to say, you got in a commercial accident.
Yep.
On a private policy, and we're not covering that. This is not leisure. It's not to and from work. It's not, you're not entitled to coverage. You violated the terms of your agreement with the insurance company.
Yeah. Yeah. That makes sense.
One of the biggest insurance companies being Progressive, you think, and we all know who owns a majority of Progressive, right?
I don't actually.
Okay, well, the scuttlebutt is George Soros owns that.
Oh, okay. Okay.
That's why they call it Progressive, right? However, regardless, but no insurance company is going to cover this type of an accident between one of them if they know that they're driving for Uber or Lyft. And if I'm the guy that got hit, I'm going to be like, your dude was hauling Uber or Lyft.
Yep. Yeah.
And then I'm coming after their house. I'm coming after their everything. But that was Uber, Lyft, DoorDash, Grubhub. That was their philosophy. We're going to take that liability away from us, place it on them. We're going to take that maintenance cost away from us and place it on them. Well, so everybody's like, well, we're changing how jobs are done. No. Greedy people that are taking advantage of other people and that are trying to work around the law anyways, are the only ones benefiting.
Okay. Yeah, it makes sense. I mean, like I said, I'll likely be voting no if that. I'll likely be voting no. I just need to read up a little more.
Yeah, I'm not trying to sway your view in any way, shape, or form. I'm just sharing information.
Well, it's good information to know because I feel like that's lacking.
Well, why is Howard Jarvis a yes on it? Why are all these other people a yes on it? Well, because it allows independent contractor. AB5 didn't allow the independent contractor.
Right.
All these groups and associations feel like the legislature is overstepping its authority and they want to check the legislature that way. Yeah. But they're not reading what this thing does, what it doesn't do. They're not looking at the facts of what the other industries similar to that have to do.
Yeah.
And they're not taking any of that into account. They're definitely not taking into an account the equal protection under the law philosophy that we as a nation and as states were founded under.
Yeah.
So if I have to have a USDOT number, and I have to have an MC number, and I have to have a CA number, and to get these things, I have to prove that I follow certain rules and regulations as far as maintenance on my vehicles, as far as inspections on my vehicles, as far as drug testing for my drivers, as far as insurance requirements to protect the public, and in the case of an accident. Why does those same things not apply to Uber, DoorDash, Lyft, et cetera, and their subsidiaries, which that's exactly what the app-based delivery driver is, a subsidiary of Uber, Lyft, and all these. Okay? And why would we as voters allow that group or that segment of the transportation industry to be any different than the trucking industry?
Well, trucking or taxi, right?
Or any kind of transportation industry. Okay, trucking and taxis are done a little different, but the taxis still absolutely have, and limos absolutely have to have a PUC authority.
Okay.
Right?
Yeah. So
that's why I'm a no on it, because it's segregating industries. And if you're in a regulated industry, we're going to regulate transportation, we need to regulate all transportation.
Yeah, I guess what I'm looking at it from is like, this makes sense from a non-regulatory standpoint, right?
But we're already regulating transportation. We're regulating interstate transportation of goods.
It's okay. I guess I see what you're saying. It's inconsistent
with
regulation.
Existing state law.
I guess what I'm looking at is the other side of it, which is, well, this is deregulation of apportionment. However, again, what you were saying, like equal protection, it just doesn't apply here when you're segmenting up portions of the industry. And I get what you're saying there. I think, I don't know. Like I said, I'm gonna have to read up more on it. I'm looking at some of the link in the description. It just like some information.
Gotta read everything.
I'm gonna read more. Yeah.
The other deal we got, I gotta say, our current vice president, man, that guy, dude's got my utmost respect. I don't know how I could have sat in a chair 12 feet away from that gal without getting up and cold cocking her.
That was insane.
That was insane. She's a disrespectful person.
Yeah, and I don't really feel like she's a good debater. I mean, she's an attorney. She should be able to be better at her job. She's obviously
she's not an attorney. She may be educated in some aspects of the law, but the law and governance are two different things.
Well, but she was a prior...
she's been a politician.
Prosecutor.
Prostitute? What?
She's a...
escort, to say the least.
Yeah.
District attorney, whatever. Lawyers don't necessarily make good politicians, and politicians don't necessarily make good lawyers.
Yeah. She was in the DA's office, and then went to SF, so Alameda, and then went to SF, and later the city, and then she was elected the DA of...
Yeah, but where'd she grow up?
She grew up in... I'm blanking.
You're
Oakland.
blanking. No, she grew up in Canada.
Really?
Yeah.
She was born in Oakland, it says.
I don't care where you're born. Her mama moved her to Canada, and she grew up in Canada.
Interesting.
Regardless, we already know what the differences in jurisdiction are in the 14th Amendment. She's not even qualified to be president. So I think we're done with the Prop 22 segment. Yeah. I think we're going to move on to this vice presidential stuff. So to be vice president, you have to be qualified to be president. We haven't had a legitimate vice presidential race in this nation in a long time.
Oh, yeah.
Yeah. So we're supposed to have 2 ballots, one for president, one for vice president. Right?
Right. When was that changed?
It wasn't changed. It was never changed. We don't have an amendment to the Constitution changing that.
I didn't think so.
Right? The parties obfuscated power again. That's the word I was trying to find earlier, right?
There you go.
Seized power and started doing what they wanted to do.
That doesn't make any sense, but sort of does make sense at the same time. Doesn't make any sense as far as skirting around the Constitution, but it does make sense as far as grasping power.
Well, I think it was probably Abraham Lincoln where they started running with running mates.
Okay.
But that doesn't make it right just because they did it.
Right. No. No, that's not what I want. Let's see here.
You know, we know that the Constitution requires electoral college.
Right.
We know, we've heard me say that electoral college has been artificially held, just like the representation has been artificially held. Okay. So, I mean, where do we have to go to find out what deals with the presidency? What constitutionally the president is responsible for? How we constitutionally elect a president? Where do we go for that?
Constitution? I don't know exactly what.
Article 2 of the Constitution.
Article 2, there you go.
It's not that much. I mean, I got it right here. It's like 2 small pages front and back. Article 2, Section 1, the executive power shall be vested in a President of the United States of America. He shall hold this office during the term of 4 years. And, together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct. See, and here's where we have to check our states. A number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. Those electors are the Electoral College. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom at least one shall not be an inhabitant of the same state with themselves, and they shall make a list of all persons voted for, and the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. Okay, so the Electoral College votes in such a manner as the legislature or the state provides? No. Nope. That's not what it said, is it? It said that's how we choose who the electors are within these boundaries.
Right.
And how many do we choose? I just read it. How many do we choose, Matthew?
I am distracted.
So we choose 1 per senator, so that's 2,
okay,
and 1 per each representative in Congress.
Got it. Okay.
Which we know representatives and senators are separate. The House and the Senate combined make up Congress, so the representatives are our U.S. district reps.
Okay.
So how many do we have in California?
So you'd have 2 for the senators, and I don't know exactly how many representatives we have. Is there, at the federal level, we have, blank on the exact numbers.
Well, regardless, it's different for every state.
Right. I don't know exactly how many we have in California.
But we have 50-some electoral votes in California.
Yeah.
It doesn't say that the electors will vote how the people say they'll vote, except for state law says the popular vote winner in the state takes the electoral college.
Right.
But here in the document that we know is the supreme law of the land under the state constitution that I have right here, it tells them how to do it. Tells them these are votes. So technically our electoral college votes, if challenged in court, don't even have to follow the popular vote of the state.
Right, and couldn't California be sued for not following that?
Yeah, but who's going to do it?
I mean, nobody, but you could. I mean, I guarantee you that's going to go all the way to this.
Right, where's it at? It said, and vote by ballot for 2 persons, of whom at least one shall not be an inhabitant of the state. So they send that to who? The President of the Senate. Who's President of the Senate?
President of the Senate.
Mitch McConnell.
Yeah.
So that's where it goes. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president. If such number be a majority of the whole number of electors appointed.
Okay.
And if there be more than one whom have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person have a majority, then from the 5 highest on the list, the said House shall in a manner choose the president. But in choosing the president, the votes shall be taken by the states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. Okay. Then there's a period. Very few places in the Constitution are there a period. Most of them are commas. Okay. So if California's doesn't certify the ballot and have those electors vote before a certain time as required by law, okay, California's electoral votes don't count, and we go with changing the number required.
Okay.
In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. The Congress may determine the time of choosing of electors and the day in which they shall give their votes, which day shall be the same time throughout the United States. And we're still in Section 1 of the executive branch. And we haven't even gotten to the president's power. But Section 1 tells us how we will elect president and vice president.
Yeah.
Now we have Biden and Kamala Harris on the same ticket. We got Donald Trump and Mike Pence on a separate ticket. When in all actuality, most of the time, and it would come down to one of the men running. So all of the men or women that are running for president are in the same pool for vice president.
Right.
Right?
Right.
And there is no running mate situation. There is no private, corporate, political party control of our system.
Yeah. Yeah.
Because you could have a Republican and a Democrat president and vice president. You could have split party president and vice president. And why is that a bad thing? It's not a bad thing. It's how the Electoral College is intended to function.
Yeah.
But not only have we changed how our officers are elected through private political party corporation control, we've now utilized that party control in the House and the Senate to freeze representation in this country. In effect, stopping Electoral College growth. In effect, changing the first section of Article 2 of the United States Constitution.
Without actually changing it.
And then you got guys like me that go on there and try to talk to guys like Josh Harder and his supporters on Facebook or Instagram or wherever these guys are posting and tell them this isn't the way it's supposed to be. Mm-hmm. It's not working legitimately for you because you've allowed it to become hijacked.
Yeah.
It's neither the Republican nor the Democrat Party. It's both parties that have allowed this to happen. Mm-hmm. Mm-hmm. And it's ridiculous. It's really, really crazy. And then you get back to...
The 12th Amendment provides the procedure for electing the president and the vice president.
But if the 12th Amendment is repugnant to this...
What do you mean?
Okay, so I believe that an amendment... How do amendments start out? They're proposed to the states, right?
Right.
You still get there. Okay, so then that was June 1804, the 12th Amendment. The electors shall meet in their respective states and vote by ballot for president and vice president, one whom at least shall not be an inhabitant of the same state with themselves. They shall in their ballots name the person voted for as president, and in distinct ballots the person voted for vice president. So all it's saying is instead of it being them voting for two people on the same ballot, they're taking and making two ballots. Right? Who do you want for president? Who do you want for vice president?
Okay.
But it doesn't say they run on the same ticket yet, does it?
No, it doesn't.
And they shall make distinct list of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes of each, which list they shall sign, certify, and transmit sealed to the seat of government, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, and such number be a majority of the whole number of electors appointed, and if no person has the majority, then from the persons having the highest numbers, not exceeding 3 on the list of those voted for president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the vote shall be taken by the states, the representation from each state having one vote. A quorum of this purpose shall consist of members or member from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, in such manner be a majority of the whole number of electors appointed, and if no persons have a majority from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purposes shall consist of 2/3 the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible for the office of president shall be eligible to that of the vice president of the United States. So then you got to go to the 14th to find out who's natural born. And it ain't Kamala Harris. But still, what did they change? That the electors in the state are now providing 2 ballots and not 1 ballot.
Right.
They didn't change anything else. And they certainly didn't say that we have running mates.
Right. Isn't that a party decision?
How does the party doesn't get to make that decision? Did anything in what I read out of this say that the Democrat or the Republican Party makes the decision?
Nope.
Nowhere. So does the Democrat or Republican Party get to make...
I see what you're saying. Yeah, because with the way that we vote is president and vice president on
combined.
One ticket, it should be president and vice president separately. I'm assuming
should not be a vice presidential ballot, period. The electors now, okay, as far as the 12th Amendment, if we were...
so we elect our electors, the electors choose the president and vice president. Which may or may not necessarily be...
It doesn't... Anywhere, the people are not voting for president and vice president.
Gotcha. Yep. Yeah.
It's on our ballot sent to us by our county clerks, right? We're voting for president and vice president.
Yeah.
Is that how it is in the Constitution?
Nope. Not even close.
So those are just who do you think? That's our states saying who do you think should be? And then our states through legislation are telling the electoral members, okay. This is who the people think.
Okay. Yeah.
But nothing in the California Constitution. Y'all know I got this. It's all done by statute.
Yeah.
How our electors will vote. So we need to add into the California Constitution mandates that the electors that are chosen by our state legislature are bound by the popular vote in the districts.
Mm-hmm.
Okay? And only the 2 electors to the Senate seats, right? Because we have 1 per district, 1 electoral vote per district.
Mm-hmm.
Those electoral votes per district represent the U.S. House of Representatives district. So that electoral vote should come out of that district's popular vote. Mm-hmm. And I got to tell you, District 10, California, while we voted for Josh Harder in the House, the district voted for Donald Trump last cycle. Mm-hmm. So that elector would go to Donald Trump. And then the 2 Senate seats that make up 2 electoral votes, those votes could go to the popular vote getter of the state, the overall state popular vote getter. But when we got we got all this stuff happening, with abolish the Electoral College and the National Popular Vote Getter gets your electoral votes. They're subverting the United States Constitution left and right, and each side is like, we're not getting our way. We're not represented. We don't have no say. They're taking advantage of us here. They're taking advantage of us there.
Yeah.
And why? Because people don't know the rules.
Yeah.
We're putting in legislators and representatives based on how they make us feel, not their constitutional viewpoints.
Yeah, that's not... No.
Well,
it's the same type of reaction that you see to Amy Coney Barrett. Based on feeling... Vote for me for mayor because I'll give you a parade once a year. Yeah, that's not... No. No, you shouldn't be basing your vote off of how it's feeling. It's out of their ability to perform their job, their constitutional responsibility to do so.
Right. So did you ever have a chance to get up my Assembly constitutional amendment proposal?
Hold on. Give me just a second here. I have it in my email. I think I linked it in one of our old episodes, but I'm going to find it here.
Well, I don't know if you did or not, but I mean, I'm kind of going to step off of this federal deal and move on to something a little Americans Restoring Representation, because I think it's a good segue with that comment about we're electing people that don't know our history. We're electing people that don't know our Constitution, the rules the game should be played by. So, I mean, now we're going to, we're getting on 9:50 here, so we need to segue into our Americans Restoring Representation, our topics.
Here, I got it pulled up here.
Okay. Anyhow, as everybody knows, I'm all about increasing representation statewide, federally. I've came up with a very simple one-page front and back, large type. It's very simple. Amendment for the California Constitution that I'm proposing to assembly members and senators. The more of us that agree with this and propose it and share it with our representatives, the more traction we'll have. But it's simply an assembly constitutional amendment, a resolution to propose to the people of California an amendment to the Constitution of the state of California, repeal and replacement of Section A, Clause 2, Article 4, therefore relating to the legislature. The California Constitution limits assembly membership to 80 members and the Senate membership to 40. This limitation causes the state of California to have a representation ratio larger than Great Britain. The representation ratio of California's assembly is approximately 1 for 500,000 persons in the Senate, 1 for 1 million persons, whereas the British House of Commons is 1 for 102,000 persons, and the House of Lords is 1 for 85,000 persons, combined at 120. Senate and Assembly California's representation ratio is 1 for 333,333 persons, while Great Britain's at 1,434 House of Commons and Lords is 1 for 45,250 persons. This simply is unacceptable and repugnant to our founding principles of representative government. We therefore propose to repeal and replace Article 4, Section 2, Clause A to read as follows: pertaining to a legislature, and Article 21, Section 1 and Section 2, Clause D as follows, pertaining to redistricting of Senate, Assembly, Congressional, and Board of Equalization districts. Article 4, Legislative, Section 2, A. 1. The Senate has a membership of 40 elected for 4-year terms, 20 to begin every 2 years until the year 2020. Thereafter, commencing in the year 2022, 20 seats will be eliminated, and the remaining 20 eliminated in 2024. 2. A. The Assembly shall have a nonpartisan membership of no more and no less than one Assembly member per 80 to 100,000 persons. Article 21. Redistricting of the Senate and Assembly, Congressional, and Board of Equalization districts. Section 1. In the year following the year in which the national census is taken under direction of Congress at the beginning of each decade, the Citizens Redistricting Commission, described in Section 2, shall adjust the boundary lines of Congressional Assembly and Board of Equalization districts, known as redistricting, in conformance with the standards set forth in Section 2. Section 2D. The Commission shall establish single-member districts for Assembly, Congress, and State Board of Equalization pursuant to a mapping process using the following criteria set forth in the following order of priority. All subclasses of Article 21, Section 2, Clause D to remain as written. This is proposed by myself, John R. Osgood III, a representative of Americans Restoring Representation. It's very simple. Why do I put the description of what Great Britain has in there? Because we know Great Britain is where we separated. And these ratios in Great Britain have been the ratios since the time of our independence. And the state of California is not in compliance with even those representation levels. Now, Great Britain is a union of 4 nations: England, Scotland, Ireland, and Wales. The United States of America is a union of 50 nations. Our representation in the House of Representatives is 1 for 750,000 persons on average.
Mm-hmm.
We've had discussion about Articles of the First on this program. That cap would have capped representation at 50,000. If we go back to what I just read you, the combined House of Commons and House of Lords is 1,434 seats for 66 million people.
Mm-hmm.
That gives them a ratio of 1 to 45,250 people. Why is Great Britain better represented than the United States of America? Because we've been complacent and we have allowed 2 political parties to dictate who's going to have power in this nation. It's time to seize control back from the parties. And as goes California, so goes the nation. We'll put this up as a link where you can grab this proposed amendment.
Yep.
We need to all be sitting down, faxing, emailing, sharing this with our representatives in the legislature and the Senate.
Yeah, absolutely. Absolutely.
Because if we're ever going to correct the state and make things like Prop 22 apply equally under the law to everyone,
mm-hmm.
we have to have a legislature that represents us. If you're over Gavin Newsom's executive orders, the legislature of 120 gave him that authority. That authority doesn't exist in the California Constitution. Nowhere in the section on the executive branch will you find executive orders.
Nope.
That's something the legislature done, and at 120, 80 and 40, it only took one governor and 62 other individuals to put us in the situation we're in.
Yeah.
I'm over it. I don't know about you.
Oh, no, I am. For sure.
So that's that. That's what we need to do. And once we get California to 80 to 100, and I wanted 80 to 100 because I believe we would have continued that pattern in Articles of the First. You all understand that.
You can go back and listen to our earlier episode.
A lot of episodes cover it.
Yeah. We have, I believe we have a specific one that covers it. I will link that.
We probably do. Nevertheless, now let's talk about how bills work, because where was Articles of the First was in the Bill of Rights. We know that that was sent out, at 12 articles. 10 of them they say were ratified, and they made those the first 10 amendments, or the Bill of Rights.
Mm-hmm.
One subsequently was ratified in the 90s. And that mean 11 of the 12 were accepted. But the first one that dealt with representation, they're still fighting whether it was accepted or not. And I want to ask you, so we had a constitutional convention, right? That this came out of? And what did they call that? They called that the Continental Congress or something of this nature? Right? Am I wrong?
Yeah, I think so.
So then we started establishing these rules on how things would work, and we sent that out.
Mm-hmm.
So that quorum of representatives chose to send a bill along with the Constitution. A bill that was agreed to, amended, passed, and signed by the president of the Congressional Continental Congression, right? Or the Constitutional Congression.
Right.
Sent to the states for ratification, but then the states were allowed to pick and choose which of those they wanted. I don't believe that was the case.
No.
It's not consistent with the principles and the rules of Congress now that have been long standing. Once a bill goes from the House to the Senate and is amended, it goes back to the House for approval, and if not amended and approved, it goes to the president for his signature, and it becomes law. That's the bill process. That's the same bill process we have at the state levels and the federal level. Now, we sent this Bill of Rights to be ratified with the Constitution. Okay? And the only one that hasn't been officially recognized as ratified dealt with representation.
Yeah.
And it said we'd have one representative for 30,000 people, up to 100 members of the House of Representatives. And then it would go to one per 40,000 up to 200, and one to 50,000 in perpetuity. And you think the states, the men that were fighting for independence, and the men who had just won independence, the representatives who were forming their nation for representation, said, no, we're not going to take 50,000?
Doesn't make sense.
Well, let's play devil's advocate on that, because the Constitution clearly says there will be no more than one representative for 30,000 people.
Right.
Now, Congress has hijacked that and said that's the basement. That you can't have one representative for 15,000.
Oh, that's the baseline. That's the minimum.
But you can have one representative for 750,000, and I don't believe that was the intent.
No.
And when we look at intent, when we look at text, we have to also look at intent. It's like the same I keep going back to 14th Amendment and jurisdiction. Two different jurisdictions. So up until a certain number on the calendar, a certain year, they based representation on 30,000 people groups, and then all of a sudden it changed, and we started dramatically increasing the number of people that were represented. So if Articles of the First was rejected, which I don't believe it could have been because it was a bill, it was part of a Bill of Rights that were sent to perfect the Constitution, or to say these are things that you are entitled to, that the government cannot take from you.
It doesn't make sense.
We should be at 50,000 today.
Yep.
And if not 50,000, we should be at 30,000. And if you don't think that works because legislation has given Congress the ability to make theirself a full-time job, then you're ridiculous. Because as easy as that wage was given, that wage can be repealed. And the serious people running for office would be talking about the things I'm telling you. With that said, Americans Restoring Representation is based all of our proposed states on 30,000 person representative districts. And we need to probably just real quick address one of those 8 states and talk about that. We talked about state number 4, or what we're calling the state of Ahwahnee, the area that encompasses the Central Valley, northern Central Valley here that we're in, Stanislaus County. So I think I did that one first just because that's our local area.
Mm-hmm.
But I'd like to do the proposed state number 1 today, which is Del Norte County, Siskiyou County, Modoc, Humboldt, Trinity, Shasta, Lassen, Tehama, Mendocino, Glenn, Butte, Plumas, Lake, and Colusa counties. Okay. That area makes up much of what is known as the state of Jefferson, does it not?
Yeah, but with the exception of Humboldt and Del Norte.
Well, territory-wise, though, that's the majority of the area that would be the state of Jefferson.
Yep, you're right.
Okay, that area is represented in the state Senate by Brian Dolly, and the state Assembly by Megan Dolly. In the state Senate by Jim Nielsen. It covers 2 Senate districts. In the state Assembly by Ramos. Again, it covers 2 Assembly districts. And in the House of Representatives by Doug LaMalfa. It would, if it was its own state, be entitled to 2 senators and 1 House of Representatives member at the current time. They would have to make that 2 House of Representatives members because it's over the 750,000 threshold, which would make them, House districts, 2 House districts of approximately 460,000 people.
Right.
Okay. Its size is equal to the state of Kentucky, and its population is equal to Delaware. Kentucky fits into California 4 times, and Delaware fits into California 66 times.
Okay.
There's just under 1 million people in this proposed state number 1, 947,341.
Okay.
Much like our area, per capita income is between $19,000 and $30,000. It's not a real wealthy area. And if they base their representation on 30,000, they'd have 31 people in their state legislature.
Okay.
Which is a lot better than what they have now.
Yeah, it definitely is.
And that's state number 1 on the proposed 8 from 1 divided together.
Okay.
That Americans Restoring Representation has. And like we said, that the majority of the area, 40,713 square miles that make up the state of Jefferson movement.
Yeah.
I think that the members of that area would behoove them to get involved with us and help us with our representation.
Mm-hmm. And how
the Assembly Constitutional Amendment? Well, the same thing that we already covered. We put the link up on our website. We put the link up in the show notes to my Assembly Constitutional Amendment. Mm-hmm. It addresses that representation issue. Okay. The courts are holding the same that the Ninth Circuit did, and a lot of these issues where state members versus the state are concerned, and the federal courts are realizing that they don't have the authority to engage in those. That there is no federal standing in those types of cases, and they're denying those hearings in those cases. They're denying those appeals in accordance with the Constitution.
Yeah.
And if we want to correct these things, we either do it through the federal courts, which then or through the state courts, which don't have any authority other than to interpret the law the legislature's given them, based on constitutionality on our state constitution. And being that no one will fight to amend the state constitution, then we're stuck where we're at, and that's why Jefferson's dead. That's why New California's dead. Americans restoring representation will not stop fighting for your representation, will not stop asking for the meetings, will not stop emailing, calling, or submitting documentation showing, as in my very simple Assembly Constitutional Amendment proposal, that this 40 million person nation we know as California is absolutely underrepresented based on the principles of Great Britain. And those principles we said at the time of our independence were unacceptable. If those were unacceptable, at one for 400 or for 45,250 combined, then one for 500,000 and one for 1 million is overly unacceptable.
Yeah.
And the way you can make this better is by sharing that amendment with your senators, your assemblymen in California, having an actual push for representation. Your parties will not do this because they lose power. Next time we'll touch on state number 2.
Okay.
We'll probably touch on the Kylie Gallagher versus Gavin Newsom and some executive order stuff. And then anything else that might come up locally in the news.
Sounds good.
Sounds
good.
Perfect. Well, I appreciate you all being here and listening, whether it's today, Monday, Wednesday, Friday, whatever day Matthew gets it uploaded. But
it will be done on Monday.
Okay.
Monday.
All right. Well, tell your friends to listen. Tell your friends to listen and leave a review. Leave a comment.
Yeah, absolutely. If you are not subscribed to our podcast feed, please do so. You can find us in all the major podcasts clients, Apple Podcasts, Spotify, Google Podcasts, every single podcast app that you can find us. Please subscribe. Please, please, please do. It really does help us out. Leave us a review if you're capable of doing so. If you want to get in touch with us, you can email us at feedback@forgottenlibertyradio.com. You can call us 209, and I am blanking on the number, 209-214-8099. That's 209-214-8099. Thank you so much for listening to this episode of Forgotten Liberty Radio, and we'll catch you next episode.